So I take these calls very seriously because
Great.
you have an opportunity to do something really wonderful for your residents. And this is actually going to set you up and give you a much better revenue stream for yourself going down the line. So it's really important to take a step back and see what's available to you. I myself, I'm not an attorney. I am an expert in measuring and mitigating microwave radiation, and I work hand in hand with the top telecommunication attorneys across the country, including Scott McCullough, who actually has won a number of important cases against the FCC over the last 4 or 5 years. Harry Lehman is working with Scott on a seminal case in California now. Andrew Campanelli, whom you met, is about to take a wolf case right through California right now. So the big stuff is happening. And the good news is that since June, when you talk to Andrew, and today, there's been a very important ruling in Flower Hill. And have you read through the Flower Hill one?
Sure, we've read it and we've circulated it.
I lobby at the federal, state, and local levels. We have gotten legislation defeated in California that was going to be, quote, a small cell deployment bill to just allow them to go into the public rights of way wherever they wanted to go. Well, we've gotten vetoes, 2 vetoes, one in 2017 and another one in 2021. The best way to do broadband is fiber optic cable. And when I say them, I mean Governor Newsom. He is the one that vetoed it in 2021. He instead is going to go ahead and put fiber optic cable directly to homes, which is how you should get broadband. And he recognizes that wireless broadband and wireline broadband, fiber optic, are not functionally equivalent services. That is an important point. You are getting a bunch of false information from the wireless industry trying to tell you that they have rights to do wireless broadband. They do not. They only have rights to do wireless telecommunications. That is the key important point. They're 2 separate worlds. Broadband is not regulated by the FCC any longer. It does not qualify for any preemption whatsoever. Whatever they might say about wireless broadband is completely immaterial to your decisions. You have to write code only for wireless telecommunications service. And wireless telecommunications service is what the act was written about. That is the ability to make an outdoor wireless phone call. Yes, outdoor, only outdoor. There is no such thing as in-building coverage or in-vehicle coverage in the law. People can actually have a right to have their own home environments. When you have huge signals outside of a building, it will penetrate the building. It will basically create a home invasion. No, that's not what the law ever contemplated. And the point is that the law has not caught up to the wireless industry desires, and this is where it is today. That's the important point. And this is what the judge in Flower Hill is saying.
Can I ask a very pragmatic question about that? And
sure.
The question is, if we have a carrier coming to us that does both broadband and wireless on frequencies that may go back and forth, how do we separate out the wireless from the broadband so that we can regulate one and not the other?
You don't have to address their needs for wireless broadband at all, meaning that if people can already you just do a test. Can people make phone calls outdoors in your town right now? That's the test. If they can, then you have every basis to say no to every single tower, and that is not an effective prohibition. So at this point, the wireless industry essentially is done. You see, they don't want to be done. They want to build new profits and new profit centers and everything else. They want to take market share away from cable companies, and they want to not do the whole FTTP thing. But that is the best thing for your town. I can point to town to town to town. Any town that actually figures out a way to do fiber optic to the premises, it is an economic boom. People move in, they start businesses. It pays off in spades. You can go to a place like Poughkeepsie and have a big business going if you have great fiber optic connections. And this has happened city after city: Chattanooga, Tennessee, Wilson, North Carolina, Longmont, Colorado, even down in Century City and Culver City in California. Just certain pockets of cities that decide fiber optic is the way to go. They get economic benefits that boom that city to a new place. You have the authority to state a preference. We prefer wired broadband, period, the end. We do not effectively prohibit wireless telecommunications. There you go. Completely defensible. There's no way you'll lose in court. And that is what Andrew was trying to tell you, is that Andrew very succinctly in the first 11 minutes laid out for you that he would be the best guy to get you to where you want to go because of his 30 years of expertise. And I have to tell you, I work with these guys for the last 5 to 6 years. St. Andrew is the best local guy you can hire. He's essentially an F-18 fighter jet for the price of a Cessna. That's who he is. And the point is, why not take advantage of the guy who's the best in the country just to get through this time? You got a lot of other code to update. You got these other things for short-term rentals and other things that you have to debate. This is something that you don't have to debate. This one is like easy in the can. The guy has the answers. I heard the story this morning. I didn't even realize he was representing the homeowners in that case. Well,
So tell us a little bit about Flower Hill.
You understand that the primary relationship is from the judges to the attorneys, right? The clients come and go and they come and go and come and go. Essentially, that judge, Frederick Block, was basically channeling his inner Andrew Campanelli. He said wonderful things there that really, really help you because this is in the Second Circuit. So allow me to share my screen and we will go and look at those great, great phrases. And I have a bunch of information in here to show you, but first I'm going to show you to Flower Hill right here. Okay, we don't have to read every word. When I put these things on my website, you will see that I do a good job of giving you a link back to the original, but I also highlight the key phrases of any one of these rulings. What happened was that the board voted down Exnet's application and they denied it for particular findings. First of all, it would have adverse impacts on the village. Got it. Second, there is no gap in wireless coverage. That's what your code can say. Third, they didn't feel it was important for them to come forward and actually provide any information to determine whether there was a gap in coverage. Your code can make them do it. So all of these things have been decided in the courts. The important part for you is you have the Second Circuit and you are bound by those rulings as well as US Supreme Court rulings and DC Circuit rulings. And so the DC Circuit and the Supreme Court have upheld your local authority over these kinds of placement decisions. I heard somebody in your planning commission on August 18th say, oh, you guys are beating us up and telling us about this stuff. It's not our problem. We have no say over the matter. Oh, our hands are tied. It's like, it was unbelievable. The guy's completely uninformed about what the law actually says and how the law has been shaped by the court rulings in the Second Circuit. He's just bought hook, line, and sinker, the propaganda line from the wireless industry. That's it. But you can easily fight back just by making your code very explicit. Then they go into substantial evidence. This is, of course, is right in the act. If you do not have substantial written evidence, then you can't make a finding based on that evidence. You're required to do so. That's why when we go in and do these things, we have a really strong record. I've defeated probably 25 towers around the country in the last year. And the way we do it is we stack the public record with actual evidence of actual decibel milliwatt readings of what is the signal strength of these different carrier frequencies. And when you do, it's clear they don't have any gaps. And therefore, you can just easily be able to say no to every single antenna until you know there's a gap. And then you say, great, let's work with you to fill that gap. That is your legal duty to do so. But they just want to overserve areas because they're doing a market share battle. They just want to take revenue away from your cable company. I don't know if you guys have Comcast or Cox or whoever your cable company is, but that's who they're fighting against. And so they're just in a market share war. That's all that's going on. But in order to do that, they're hurting your town. Well, you don't have to go along with that. So don't. save your town. You're served by the least number of cell towers. That's how your town preserves its character, its residential values, and everything that you need in your town. You don't need ubiquitous wireless broadband. You don't. It's not a value that could be in your town. You could say, we have decided to be an energy efficient green town that depends on moving big data on fiber optic cables, because that's the energy efficient way to go. Great. You're well within your legal rights to say that. And there's a really important reason why, but let's finish up with Flower Hill. Here's what he says. Now let's talk about what a landline is versus what a voice over IP phone is versus what a cell phone is. But in reality, they all do one thing. They all have information that leaves my mouth and it travels over something to get to your ear. That is an instantaneous transaction. And there is no storing of it. There's no caching of it. There's no processing of it. It is just there. That is the definition of telecommunications, right there, right out of the federal code. No changes, no storing, no domain name service, no caching, right there. It's all been defined very, very clearly. So now you sit there and go, well, is it important that he said landlines? Well, he's not quite with the times. I have service. Fiber optic comes to my home. I get a phone line with that. Is that technically a landline? No, it's not. It's actually going over the internet, using internet packets of information. So when he says landline here, I'm going to think he thought about both voice over IP and traditional switched telephone lines. But the whole point is that they have to participate in the existing telephone communications structure. And that is it. That was the whole point of the 1996 Telecommunications Act. It did not anticipate wireless broadband. It never even thought it was going to exist. And in fact, it grew up beyond the law. So it's out there as a business activity that is not actually regulated by the law. So here's the other key thing. It is indisputed that a signal strength far less than Verizon's desired minus 85 dBm would still be sufficient to make a phone call. I'm going to take you to the WTF report card. Very simple thing to do. We all know report cards. We all got them. Maybe they weren't handwritten, but they are A's, B's, and C's. What else do we know about report cards? We know that, the numbers kind of correspond to the grade, right? So if you got between 90 and 100, you're an A. In the 80s, you're a B. Below that, you're C. Do you want your kids to get C's and D's? Oh, no. We coach them up to get A's and B's. All right, great. Can we have a report card for the wireless industry? Well, of course we can. How do we do that? We tie it to decibel milliwatt. When you go down, you have the 1934 Communications Act. This is very old, but it is true. In section 324, this is what they tell you must happen. Use of minimum power in all circumstances. Oh, well, if for some circumstances, it's okay. Oh, no, all circumstances. Well, how many of these things? All radio stations, of which a cell tower is. Shall, may, it's a good idea if shall use the minimum amount of power necessary to carry out the communication desired. There it is. What is the communication desired? The making of an outdoor wireless phone call. How much power does it take? The judge in Flower Hill told you far less than minus 85. Let's see how much farther less. All right. Here's your report card. Minus 90 to minus 125 would be excellent for your town. You can make a phone call all the way down to minus 125. This is called decibel milliwatt. It's important to understand what that is. I can explain it further if you want. But it's just a radio signal strength unit. And what it says is, if you had this everywhere in your town, you would never have a problem with somebody getting hurt or injured by a cell tower. That is not what is happening. So look, even if you get to this minus 85 thing, which was their goal, which the judge said, look, we all recognize you can go way below that in order to make a phone call. Well, that would be a B. All right, we'll work with everybody who's got A's and B's. We like A and B cell towers in our town. Hey, anything out there that's higher than that in power? Excuse me, at minus 70 or minus 79? No, that's excessive. We're not going to go with that. We're going to work with you, and we're going to try to get an even spread of minus 85 to minus 125 everywhere for every carrier. Therefore, everybody has service. There is no effective prohibition. There's no reason to sue anybody. But what you will take care of is all the excessive pollution that's happening in your town unnecessarily because you're not thinking about how much pollution it is. So that's why it may make sense to talk about decibel milliwatt. I'll go somewhere else to do that. But what you see here is directly from the industry. 4G LTE minus 99 dBm is excellent. Minus 91 to 105 is good. Minus 106 to 110, I still can do it. Oh, finally, when it get down to minus 120 or so, maybe that's not enough. What is a decibel milliwatt? This is where I explain it. This is important to understand. A decibel is just a fraction. It's like 1/10 or 1/100th. That's all a decibel is. It's just showing a fraction. A decibel milliwatt is just an arbitrary way to say we will define 0 on the scale to be 1/1000th of a watt. And then we will look at fractions from there. So when you talk about decibel milliwatts, you use negative numbers because 1/1000th of a watt, surprisingly, folks, is a lot of power when you put it through the air. You do not want to live anywhere where there's that 1 decibel milliwatt or 0 dB. That's why you want to be down at minus 80, minus 100, minus something like that. Because if you get up higher than that, you understand that minus 40 is much higher than minus 80. So that's it. It's used in radio communication to be able to talk about these large swings in power. This is right in the 1996 TCA, the term functionally equivalent services. And you go searching for a definition, and it's not right there in the act. Where is it? It's in the conference report. What happened to that conference report? It was recognized by the U.S. Supreme Court justices in 2005 as the definition for functionally equivalent service is personal wireless services, which is the making of an outdoor phone call. The wireless industry tries to tell you that wireless broadband and wireline broadband are functionally equivalent services. That is a false statement. It is clearly stated in the court ruling that functionally equivalent services are only personal wireless services, which is only telecommunications, the ability to make an outdoor phone call. That is it. A mobile service is a radio communications service carried on between two mobile stations or land stations. Every single cell tower is a radio station. That is good. How do we know? They need a license from the FCC in order to operate. That's how we know. What does that make it? Subject to 324. Because it's a radio station, in all circumstances, that cell tower shall use the minimum amount of power to carry out the communication desired. You don't need to go to $25,000 meters. You don't need to go out to RF experts. You can actually get this done with your own city staff because it's actually very simple to do. There are two types of meters. There's something called a broadband meter, something called a spectrum analyzer. Think of it this way. This is going to read every radio signal out there that there is, and it's going to give me the total of everything I see within the range that my antenna is tuned to see. The 4G world is 700 megahertz to roughly 2100 megahertz. The 5G world right now starts at 600 megahertz, includes all that 4G stuff, and goes up to, could be as high as 39,000 megahertz. Now, a spectrum analyzer would be able to look at the range and then report back to you specific to the carrier. That's the key thing. It'll give you a nice little reading that says, oh, in this part of the city, we can see that Verizon at 724 megahertz has a nice signal strength reading of minus 72 dBm. Great. And you continue on. and it will give you every single reading of every carrier out there. And you can actually just drive the streets, gather this information, stick it in the public record. Now, everybody has a chance to look at it and use it for planning purposes. You don't have to play this little game of you go ahead and bring us your gamed data. No, you get to gather the data yourself. It's very inexpensive to do. And any costs that you have can be apportioned back to any of the antenna operators on a pro rata basis. Everything in life is a trade-off. Radio frequency microwave radiation is a trade-off. You pump it into your town in order to use it for communications. That's the upside. The downside is you're polluting your town at the same time. How much pollution do you want to allow in order for radio frequency microwave radiation communications? That is the decision you need to make. And so it's really good to understand that in your town, 62% of the pollution is coming from Verizon. Well, that's all right. Now Verizon will pay 62% of the cost of our every 6-month reading. And that every 6-month reading is called the We Want It bill, WEWANTIT. It stands for Written Evidence Wireless Antenna Need Test in Telecommunications. We want it. And it's simply this. Every 6 months, we'll do a drive test. It'll cost us $1,000, $10,000, doesn't matter. And then whoever's operating in our town, and this is everybody, including your police people and everybody else, you're going to pay a percentage of the bill based on how much pollution you could put into our town. And we'll understand that by your antenna specs. Perfect. This is chump change for these people. Doesn't matter at all. It's just a condition for getting an operational permit in your town. And this way, you have the evidence. You don't have to debate it. You don't have to go through these long proceedings. And what does that mean? What does this mean? And you go, no, they are DBM readings done with an instrument I'm about to show you. Everybody will stipulate that it's all fine. And then you make decisions. Here it is, the Wilson Pro Cell Link Meter. You got a link to it right here. It's about $600. It's a good, smart instrument. We've used this in Idaho to basically say no to cell towers there, proving there is no significant gap in coverage. It's very simple. You connect it up to a cell phone. It spits out a nice little spreadsheet. It shows you every carrier, every frequency, and they have one coming out that's going to read all the C-band stuff. See, this is exactly what the FCC said to the wireless industry. We don't believe your propagation maps anymore. We just don't.
So this
We're going
map's
to go out and
based,
do our own readings. Pardon me?
Paul, so this map's based on GPS signal, so you have a map of where everything is?
Absolutely, it's GPS. I will show you the data. I think it's on the Poughkeepsie page, but I'll also show you where I put it on the Idaho page right here. Star Idaho. 1 second here. Star Idaho, right there. We just did this a couple weeks ago. The tower they were going to put right here, and we showed there was no significant gap in coverage, and I will show you exactly where those pictures are. All right, here are the pictures. All right, so I'm going to fast forward and get right into output of this instrument. This is it right there. Bang. It's a little hard to see. I will try to make it bigger. All right. So these are just columns. Here's AT&T mobility, right? You got certain frequencies. You've got DBM in what they call, these are just radio terms I can go over later, but it's important to look at all 3 columns, see what the numbers are, okay? And you get your GPS coordinate. You get all the T-Mobile, all the Verizon Wireless, all the AT&T. You get it GPS by GPS. This is the information you need to make decisions for planning. It is not hard to do. It takes no expert to do it. It's easy and simple. The thing comes with a 3-year warranty. They provide good service. And this is all we did. We went to 12016 West Floating Feather Road. We used this instrument. We brought it in. The AT&T engineer and made a statement under penalty of perjury that the data was accurate. Our data, he accepted it as accurate. And that's all it took. And they said, no, thank you. We don't have a significant gap in coverage. There's one provider that may have a significant gap in coverage. That is Dish. And that is because Dish didn't get started until roughly 18 months ago. So Dish might need to be able to come in and put some cell antenna somewhere. But guess what? You already have, 300 or 400 antennas in Poughkeepsie. They could co-locate on all of those. No one has to build another new cell tower in Poughkeepsie in order to qualify for no effective prohibition. because you have enough infrastructure already. And they all cry bellyache and go, oh, but we want to do wireless broadband. And you say, I don't care. Take that up with your elected representatives. The law doesn't allow you to do that. So, we're going to make sure you're going to have phone calls, period, the end. That's it. Why is that? We want data moved efficiently in our town. We don't want a bunch of poison in our town just so people can stream video onto their cell phone. Hell no. In fact, we don't think that's a good local value. We don't like people walking out into traffic watching video.
Well, we do have Dish coming into the area and they have been co-locating.
Good.
How do you know when they reference, for example, 3 different potential not broadbands, 3 wavelengths that they want to operate on? How do we know what's like wireless, what's broadband, and is there a way to parse it?
All right, let's take a look at this, for example. Okay. It's important to understand this scale before we get to the frequencies. You have to understand that each of the frequencies can be measured by this kind of power scale. And that's what the spectrum analyzer does. It breaks down for 700 megahertz, what's my signal strength? For 824, what's my signal strength? For 2522, what's my signal strength? All right. So this learning I'm about to give you can be applied to each one. Okay. So what do we got here? Well, this is the magic, 0 dBm. That is what I already told you. It is just a decision and it's arbitrary, but this is what the industry said to make a standard. 1/1000th of a watt will be 0 on our scale. Understand that. Well, then you have a scale that goes down by -10, -20, -30. And each time you go down by a factor of 10, you add an extra 0, right? So that's what it means. Here I am at -85 dBm, which the industry says is great coverage. It's 0.002, all right? If I wanted a 10 times higher, I'd be at 0.02. If I wanted to go to -65 dBm, I'd be 20 on the scale, but I'm 100 times more. If I go up to -55 dBm, I'm 30 on the scale, think of 3 zeros, and now I'm 1,000 times more. Do you see? I'm 1,000 times higher than what is needed for 5 bars on a cell phone. All right? Go the other way. If I'm at -115, I'm at 1/1000th of what they think is great coverage. I can still make a phone call. If I'm here at 1/10,000th of what they want, I can still make a phone call. It may be a little spotty here. This is now coming down to what might lead to a gap right there. So what are we finding? When they do these silly propagation maps, no one's paying attention. They label their little green color as -85 dBm or higher. What is in Hank Allen's backyard that has made him sick and made him go to the hospital? This one, -10 dBm. It is between 10 million and 100 million times higher than needed for 5 bars on a cell phone. That is why he's getting sick. And then you ask yourself, well, how can this happen? Because no one is enforcing Section 324, that you need to use the minimum amount of power for the communication desired. They're allowing them to indiscriminately spread pollution at huge levels all over your city because no one has decided that we want to protect people. Well, this is how you protect them. You sit down and go, the whole thing is out of control. It doesn't need to be this high. It shouldn't be this high by law. We're just not paying attention. So let's start paying attention.
Carl, can I just ask, from a topography issue, you often see on these coverage maps, you can see the topography where it will reach out when it's flatter or get stopped because it's all line of sight things. So don't you get some higher signal strengths in some closer areas than you do where the topography hides it to get to the 85?
That is correct. And so when you sit down, you go, is this really complex to get an exact answer? And the answer it is, because think about a light bulb in your room. That has electromagnetic radiation. Even visible light is electromagnetic radiation.
Yep.
So when you turn the light bulb on, what happens? Well, it fills the room. All right. So it's kind of going everywhere. but it's brighter in some parts of the room and not in other parts. Why? Well, you're getting something that shades it. And then you have things like hard shadows and soft shadows. Well, the same thing happens with radio frequency microwave radiation, right? And so the whole point is that it's a huge variability of what's going on.
Mhm.
So every time it thuds into something, whether it's a hillside or a tree or a person, you have to understand that people are some of the best antennas there are, and we will actually absorb this probably more than anything else. Hey, you want to make even a better antenna? Let's get an 8-year-old child. They're a much better antenna than you as an adult. They're the right size. They have higher wider content. They're taking on a lot more of this poison than you are today, because this is how it actually works. So then you sit down and go, okay, well, do I have to go and deal with all that complexity? Well, no, not for making good policy, but it is true. The further away I get, the signal will go down in power. The more things I thought into, that will go down in power. Think about it this way. If you had the magic technology and you said, well, here's my source information cell tower in the middle of my town, and I had the ability to take jelly on a piece of bread. My town is flat, it's square, it's about the size of a giant piece of bread. And I'm right in the middle, and I put a blob of jelly in the middle where the tower is, but I'm able to evenly smooth it out to a nice thin veneer all over the town. Well, that would be perfect. That's exactly what would be great. It doesn't work that way. What really happens is the blob of jelly's in the middle. You never get rid of the blob. You just take the edges of the blob and you spread it thinner and thinner and thinner as you go to the edges. But the people living near the blob are screwed. And how do I know? Because you just go and measure. I measure things like this in people's bedroom windows, okay? From small cells. You have to understand that the inverse square law works exactly in the reverse. They always tell you this way. Oh, well, you go out 100 times and it will be 10,000 times lower, 4 zeros, all right? And you sit there and go, oh, hold on. If I get 100 times closer, I'm going to be 10,000 times higher. And that is what a small cell is.
Yeah.
The power you're getting off a small cell is much more dangerous than what you get off of a macro tower, because you have to think about 3 variables in geometry. It's vertical, horizontal, and maximum power, VHP. How many feet off the ground am I? How many feet away am I? And what is the maximum power output that you can put through that antenna? You have to understand who I am. I am really technical, okay? I am the top. I'm that nerd from your class that graduated #1 in the class. I got to Ivy League schools on academic scholarships. I'm the nerd guy, okay? I read every manual. I get to 4th level tech support. I called up Amphenol Antenna 5 years ago. I got this guy, Mike. He wouldn't give me his last name. He says, I've been working here 30 years. You need to have good information. I'm not giving you my last name. What else? What do you want to know? I'll give you half an hour. Go. Here's what he tells me. Every single antenna is way over engineered. They are bringing into your neighborhoods essentially weapon systems. And they tell you, oh, we're going to run this thing about 10% of its value. Okay, great. They get you all to approve it at 10%. Then what could they do? They could run it 100% anytime they want. What else could they do? Oh, it's designed to run at 200% of that. Hello? Why are we allowing them to have such overpowered antennas in our neighborhoods next to people's homes? You don't need to do that. So if you had to compare what they're doing, these antennas that I see that go on small cells in front of people's homes are 15 inches in diameter and 4 feet tall. And you take the cover off and there are 3 separate panel antennas in there. We're talking over 50,000 watts that can come out of those antennas. How much do you need to make a phone call? 0.02 watts. That's really what's happening. So could you say to them, yeah, that's way too big. Why don't we bring back something that's 4 inches tall and a 1/2 inch in diameter? And you know what? That will work. That will be sufficient for phone calls. Every one of these antennas, even though they're 2 feet tall and 4 feet tall, are on the same principles as the antennas on the macro tower. They are macro towers. How do we know this? The FCC treats them exactly that way. In 2019, there was a ruling in August, Kitawa. It wiped out the definition of a small cell right there in that ruling. The FCC never reestablished the definition properly. They're just pretending that it's still there. When you press the FCC, and I do, I talk to them every 6 months with an attorney on the line. They treat every single cell tower as equal. Every macro tower is the same as every small cell. That is the truth of the matter. Every single one, according to the FCC, must undergo NEPA review. That is the truth of the matter. I have it admitted directly from the FCC. I can show you exactly where she says it. Because you can deal with decibel milliwatt, because every analysis out there is in decibel milliwatt, you never have to write your law with respect to compliance to the FCC guideline. That's it. Don't even mention it. It's not even important. If you are in this territory of minimum amount of power, you have no chance of ever getting close to the FCC guideline. The FCC guideline is going at 30 million miles an hour. That's really what it is. It's so much higher than what is needed for this stuff. It's just nonsense. So don't write your laws pegged to it. Write your laws pegged to how much power is needed to get the job done. Period. The end. That's it. And the industry has already published what they need. You can easily go out and find substantial written evidence that says, yes, signal strengths anywhere from -120 to -85 are what we need. But do I get towns to come out and say, no significant gap in coverage based on these readings? Yes. Do they stand up in court? Yes. The whole point here is to figure out what are the important principles, and then how do I get through the eye of the needle to just essentially save my town? That's all. And the best way to get through the eye of the needle is to take the guy who's been in the back rooms of the judges for 30 years and say, Andrew, keep us out of court and keep these people at bay. Boom, he's your guy. Here's your FCC guideline. Let's take a look at this right here. In frequencies that are above 1500 megahertz, they kind of end up to a particular number, 10 million. However, that's not true at 700 megahertz. 700 megahertz is much lower. And you also have to understand that there's a big problem with the FCC guideline. We know this, but here's the problem. We based it all on specific absorption rate. And when we did that work, we only did it up to 6,000 megahertz. So what about stuff be above 6,000 megahertz? Do you have any guideline? We didn't really do any work, so we'll just say it is. That's what they tried in the order that went to court. The judges threw up on that, and they said, no dice, you better go do your work. So today, right now, in Poughkeepsie, New York, do you have a federal guideline for microwave radiation exposure above 6,000 megahertz? You do not. Do you have the basis for an operational permit for any antenna going higher than 6,000 megahertz? You do not. You can put that right in your code.
As of yet, we have not had any providers trying to go to 6 gig.
There is no proper microwave radiation guideline above 6,000 megahertz. All you have to do is go to that court ruling to figure that out. And let's just say the following. We will treat every application as incomplete until the FCC completes its court-mandated work in the 2019 decision Kitawa versus FCC and the 2021 decision of Children's Health Defense and Environmental Health Trust versus the FCC. There are very specific things that they were mandated to do, and the FCC has not done them. You can't force us to go down this path until the FCC does its work. Therefore, it's now incomplete. Okay. Number one is there are big holes in the microwave radiation guideline beyond what I've already told you. Yep. And the courts recognize that. And they have essentially done the proper thing to say, hey, you're going to have to take another look at this because we're sitting on a bunch of evidence that has proven it is not protective. Okay. And so they gave them that directive. All right. So that means that applies to every single cell tower operating in the United States today. And that doesn't matter about the frequency. Now, I appreciate what you're sharing with me with regards to whether you believe it would stand up in court or not. And I'm going to say two things to you. Number one, nobody can accurately predict the future. And number two, it really doesn't matter what you think or what I think. It matters what a judge says. And so it really just depends on, are we willing to actually go and make a statement and go defend it in court and get some learning? And I think it's okay to get some learning. I don't think it's the end of the world to go in front of a judge and explain to him what's going on and see what they have to say. Here's what I would take in front of the judge right here. It's on the front page of wireamerica.org. I'm going to take you right to the evidence that really matters. Boom. It was so good, I put it on my front page. You have received this. This is in your public record. Here we are. I'm looking at a picture of what? 11,000 pages, 27 volumes of scientific evidence proving that the microwave radiation guideline is not protective. Cool. We're the judges. We took this into our record. What did we do? Did we reject this? No, we accepted it. Did we read it? Well, not all of it. The agency has to read it all, but we see it's big and it's important. We're going to tell the agency to go read all this. Okay, good. Well, what did you do then? Well, we ruled based on this. That's what we did. We wrote really specific words. We wrote, we grant the petitions and remand to the commission to provide a reasoned explanation that its guideline adequately protects against harmful effects. In particular, we said you must provide a reasoned explanation that your testing procedures mean something, which they don't. We need you to address the impacts of RF radiation on children, the health implications of long-term exposure, the ubiquity and other technical developments that have occurred since you last updated this thing. And you need to address the impacts of, wait for it, RF radiation on the environment. Oh my goodness. We had a ruling that said that you actually do have to look at the environmental effects. Period. The end. You have been ordered to do so. This is not optional.
But they haven't yet said, they never said that the regulations are no longer in effect, or that they're that we should ignore them, right? As a local municipality, they said that we think the FCC should do a better job explaining their regulations and look at all of this evidence and come back with something. But that hasn't happened yet, right?
Well, that's what I'm trying to tell you here.
Right.
All right, so let's tell you this. You're about to buy a car.
Mm-hmm.
You have no idea if the brakes are going to work. Are you going to be forced to buy the car until you're sure that the brakes work? I don't think so.
I get that this case told the FCC, you got to do a better job, come to the fore, give us the information we need, address the impacts of RF on the environment. But this did not say that because you haven't done this, the existing code, the federal statute that binds us all is, unconstitutional, not in place, and can't be followed. So until we get that decision, I feel like I'm bound by that. Now, I love everything else you've said about ways around it, but I really feel that, our hands are tied on the RF effects, but we can regulate, all the other things, the gaps in coverage, and get backdoor it. But I disagree that, this telling the FCC to go back and fix this, or at least look at it,
right,
is undercuts what exists, that particular code section.
Okay, so I agree with you that you're bound by certain things. I agree that you're bound to follow the edicts of the 1996 Telecommunications Act, as well as U.S. Supreme Court rulings, Second Circuit rulings, D.C. Circuit rulings. Not FCC orders, however. Okay?
I agree with that. Don't disagree with
only
you.
certain orders.
You're right.
Okay, not all of them. Okay, so let us do that then. Let us quickly look and make sure that we really, really understand what it's telling you, because lots of times even Andrew Campanelli made a statement that wasn't totally accurate in what we told you. And it really comes down to an Oyster Bay case that happened in your Second Circuit. And I'm happy to show you those two things right now. It won't take very long. All right, let me go here to compare the 1995 and 96 version of the 1996 Telecommunications Act. But before we do that, we are presented with United States Supreme Court 2005 ruling in Rancho Palos Verdes versus Abrams. This is a beautiful thing. And I'm going to tell you that what you just said is that, oh, we don't have the authority. Our hands are tied with respect to RF. And the answer is that is not true because of this. Congress initially considered a single national solution. This is Justice Breyer writing, with whom O'Connor, Souter, and Ginsburg concurred. All right. They initially considered a single national solution, namely an FCC citing policy that would preempt state and local authority. How do they know? They look at the conference report. But Congress ultimately rejected the national approach, good, and substituted instead a system based on cooperative federalism. This is what we are under. We are under cooperative federalism. This means that you have zoning laws. Your zoning laws are completely respected in this whole world. All right. And you are to take everything that's not been preempted from you and apply your zoning laws to the final decision. You are fully respected. And I'm going to tell you, if you take a look at a percentage breakdown, you probably hold 70% to 80% of the authority over these issues. Okay. You are just scared when you mention RF, because there is some case law out there saying, oh, you can't really touch our RF. I agree with you. Okay.
No, it's not case law, it's a federal statute.
No, just so we're really clear, the federal statute is letting you do it, and you'll see why in a second.
Okay.
Here's why. The regulation of the operations of cell towers was never preempted from your authority. You hold it today, you've always held it. That is according to the law. Why is that? We had two versions of this law. We had one in 1995. We had the one that was actually passed in 1996. It's the same thing the judges were referring to above. We initially considered the 95 version, but no, there was deliberations. People got in the way. They changed the whole basis for the one in 96. Well, what were they trying to preempt in 1995? 4 things: placement, construction, modification, or operation of cell towers. See? Now, let's look at the same paragraph in 96. Placement, construction, and ding, 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 no operation. In a world of cooperative federalism, if it is not claimed at the federal level, it falls to the states. If it is not claimed at the state level, it falls to the locals. Today, Poughkeepsie, New York, your elected representatives have the authority to regulate the operation of cell phone towers because you have the obligation to deliver actual safety to your residents, period, the end. Yeah. That is the truth of the matter in the law. I am going to show you it happens, continues on, okay? What happened here? Oh, all right, let's go down to that RF thing. A state shall act on any request to locate, construct, modify, or operate facilities. Operation's gone over here. Let's look at the environmental effects. The policy described pursuant to this paragraph shall provide no state or local may regulate placement, construction, or operation based on the environmental effects of radio frequency emissions. Well, what did they pass? They passed this one. You may regulate the placement, construction, modification. Hey, where's operation? Look at that. It's not on a list, meaning it hasn't been preempted from you. Holy crap, look at that.
So how do I regulate the operations without regulating the placement, construction, and modification?
Easy.
Good question.
Size of the antenna. Amount of power you allow them to have.
Okay, so I don't think we're actually disagreeing about the same.
Hold on. So let's really make sure you understand what I'm saying here. Okay. We have to make certain decisions here. And when we make them, the decisions that we are making that are preempted from us are, do you get to put it there or not? All right, well, maybe I can't affect that so much. Do you get to build or not? Well, in certain circumstances, I can't affect that. If you want to come by and modify it, in certain circumstances, I can't affect that. All right, understand that. Those are things where I'm a little hands off. When it's time to give an operational permit to say, now it's time for you to actually get electricity to your unit and start running it, you have full authority over that, and you have always had it. And when you make that decision, you are not constrained in any way, shape, or form by this law. Understand what this really means. Now, I'm saying to you is that these 3 decisions are constrained by not looking at environmental effects. We understand that. Now you're about to make an operations decision. Are you constrained by not looking at environmental effects for an operation decision? Of course not, because that wasn't taken away from you. You have the ability to regulate the operations of cell phone towers and have the ability to look at environmental effects for the operational aspects and have the ability to look at the health effects for the operational aspects of cell towers according to the law. What you're only telling me is, oh, we're just lumping this together as one kind of fuzzy category, and that's why we believe it includes health effects. Does it say health effects there? It does not. Does it say environmental effects? It does. For which decisions? placement, construction, and modification. Only. You understand?
Can I ask-
Paragraph A tells you that right here. Nothing in this act, you understand, nothing shall limit your unlimited or affect your authority to do stuff regarding placement, construction, modification other than these things we list as limitations. Therefore, everything else is on your plate. If it is not specifically taken away from you here, you have it. Was operations of cell phone towers taken away from you in this code? It was not. You have it. You've always had it. You have it today. Your hands are not tied.
Are you suggesting that the way to do it would be to allow the towers to go wherever they want, but then go around and test them from time to time to make sure that
No,
they're
no. What I'm
operating
saying to
within
you,
those
what
things?
I'm saying to you is to put exact, specific constraints in your code, and do it by setting what are allowable power limits based on the minimum of power needed for the communication desired. To me, that is the win, 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 win. If
And when
you
you say power, you're talking about the decibel.
80, yeah, minus 85 dBm.
minus 85
Okay.
dBm, you'll get no argument from anybody that minus 85 dBm is good coverage, and can make a call all the way down to like minus 115 or minus 120. For example, would it be within your code to say we don't want a cell phone tower any shorter than something 200 feet tall? That's we in Poughkeepsie find that aesthetically pleasing. Yes, you could do that tomorrow.
Sure.
And that could be your law. And guess what? They would be nice and high, and it would be far over your people, and it wouldn't be so dangerous. This whole thing of, oh, it's a good idea to put these things small so that they don't look bad. Heck no, you're moving this poison closer to people. You want them as tall as possible. The beauty of 200 feet is that now you have to register yourself in the FCC database. Now you're part of the public record, and everyone gets a chance. And if you're going to report that tower, you've got a way for the FCC to actually touch it and have jurisdiction over it. Now you can use it. But prior to that, it's the wild, wild west. The FCC doesn't want to know. They want to look the other way. They all build these towers at 199 or less. They have no idea how many towers are out there, and that's what they prefer. I say to every little town that you can, if you had, 10 tall towers in your town and co-located on tall towers, you're done. You don't need another tower anywhere. You don't need another antenna on any building or any other place. The fact that they've wiggled their way in every little nook and cranny over the last 25 years is just people not realizing that they had the power all along to fix this problem.
Can we
Right.
go back to Lisa's question earlier on, which is how do we differentiate between a proposal for telecommunications and wireless?
Broadband.
Yes, how do we differentiate that? How do we differentiate?
Okay. Let me do that
those
for you.
things? Yeah.
Let me do that for you. There is a beautiful little website here that allows you to scrape the FCC's records in order to see what are the actual licenses that are owned by carrier for your town. Great. You could put together this list for Poughkeepsie. All right, let's take a look. Bunch of stuff down here. Some names you'll recognize, some names you don't. Okay, and I'll make it a little bit bigger and maybe easier to see. Okay. So Dish is the new carrier. They got a little slice of bandwidth down here, maybe 5 megabits of bandwidth. What is that? That's just subtracting these two numbers. You see, they talk about 600 megahertz, but in reality, they have a little slice of frequency that's specifically theirs. That's their license. And they have to stay here. Otherwise, they'd be stepping over another provider. All right. So they get 5 megahertz of bandwidth on this channel and 5 megahertz of bandwidth on that channel. And that's all the Dish bought for that geography. Now you can look at your own geography and figure it out for yourself. Okay. But they have different labels for all these things. Okay. But the only ones that really matter are that, what is the carrier? What's the range? What's the bandwidth? That's all that really matters.
We get those, and they go from 600 megahertz up to, let's say, 3600 megahertz. We get copies of all the FCC licenses and so on.
Cool. Great. Let's talk about them then.
So, but
now you want to say, how do you differentiate between them? That's your question, right? Good,
Right.
good. Okay. So now our goal is to realize that they behave a little differently. We all know that the 600 megahertz stuff is a lot like the 700 megahertz stuff, meaning you put it on a tower and it's going to propagate a fairly good long distance. This is excellent for phone calls. This is exactly what you want to use for phone calls, right? So you then move your way up into 800 megahertz. And yes, you could use this for phone calls too. And then you kind of get to higher than that. And they've used this in the past for phone calls. And then boom, you jump up to 1695 to 1700. Okay. I will tell you that even though it's possible to do phone calls on these, it's not as good for doing phone calls on these. All right. And so your answer is your breakout is probably right there, right at the 900 mark. So you can safely assume that even though they may run some other services in addition to phone calls, that you can say, hey, if we got service of 6 or 7 or 800 megahertz, we're good to go. And
Do you have
can
a
make phone
document?
calls.
Like something that would tell us that, under 900 megahertz is 600 to 900 is decent for phone calls and above that, not so much? Because I haven't been able to find something like that.
All right, I probably do. And off the top of my head, I don't know, but I'll look for you and I will stick it in your inbox as soon as I find it. Okay.
The lower the frequency, at least the farther it will transmit. So that's
Correct, and that's why they do it. So think about this: you have a bunch of small cells in your city. All right, they're apart by 500 feet apiece, and you're going down the block. Okay, and you're in the midst of making a phone call. Are you really using those little small cells for your phone call? No, not really. And why is that? Well, if I'm driving down the road and I've connected to the one tower, now they're going to have to do a handoff to the second tower as I go down the road. Well, every time you do a handoff, there's something could go wrong. You could lose your call. Why would you do that? No, we're going to handle the phone call parts of this way up there on the big tower because it can see the whole drive you're making going right past all these small cells. Well, then are these small cells ever needed for phone calls? No, they're not. They are completely for wireless broadband. Oh, cool. Do I need them? No, you don't. Do I have to have them? No, you don't.
Well, I think that we should have, like what Lisa's asking for, though, some sort of documentation that indicates pretty clearly that anything above 900 is going to be for wireless broadband, not
Okay.
telecommunications.
All right. So now we're going to enter the world of Scott McCullough. Okay. And I do have very deep conversations with Mr. McCullough, and I will share you documents that will put you to sleep. But it is all about the way that a carrier will go ahead and do the handshake process for managing phone calls. And understand what they are trying to do. They are trying to inextricably mush together their data frequencies and their voice frequencies so you wouldn't be able to separate them apart. Okay, they are anticipating where you're going, and they're trying like hell to make sure you're not going to be successful going there. Okay. Yet they can't get away from what has already been written by this whole thing of what is a covered service, what is not a covered service, and what is a handshake for a phone call and what is not. Now, the whole we're going to send data in addition to a phone call thing was kind of just allowed to come along. Okay. There was no special authorization for it. Okay. There was no special gift given to it. It is what it is. And they're trying to say, well, we'll just commingle everything. And everybody kind of looked the other way and allowed it to happen. Guess what? You can ignore it 100%. And you could just sit there. Look, you have data plans that may or may not come along, and that's fine. And I don't have to deal with any of that. But, do I have to worry about whether you have a gap in 3,600 megahertz? Hell no, I'm a city. I have to worry about one thing. Can my people make a phone call or not, regardless of the frequency you use? And that's all I need to do. So I don't have to duke it out with you and your frequencies. All I have to duke it out is what is the signal strength? And then look, if you have signal strength in 600 and 700 megahertz and you choose not to do phone calls on that, it's your choice.
So that's
we're not prohibiting the service.
I recommend the drive test for then.
Yes, you bet. The drive test is exactly what you want. Okay. And I have language right for it. I'll give it to you. And let's see.
So versus trying to regulate frequency, then you look at that.
Yeah, the point is that you want to be able to understand what your signal strength is by frequency. I'm going to leave the page and then go right into solutions. We want it right there. Okay. And it's a paragraph. It's very, very, very simple. Okay. We want a comprehensive wire signal strength test every 6 months. There it is. And you put that in your code. All right. We'll log second by second the signal strength and decibel milliwatts of every carrier specific licensed and unlicensed frequency that's being transmitted to the streets of our city. The full data will be placed on the public record so everybody can view it. Public, planning, carriers. We're not hiding it from anybody. Everybody can see it. And it will serve as the basis for my decisions whether or not we need it and whether we then place, construct, or modify our operations of it. See? And the cost will be shared by all antenna operators on a prorated basis because you're all polluting my town and you have to bear the cost of the pollution. Very simple. You put that in, now we're talking. Now you have real data. Now nobody can run away from it. And look, this is what the FCC actually wants, right? The FCC went out and they went, you heard it, maybe you haven't heard it. They don't believe these propagation maps, okay? They went out and did 26,000 miles of tests. I think Andrew told you this. And they figured out that the propagation maps are just BS. And so it's all about DBM readings. It's all about these drive tests. And there's the instrument to get it done. Is that Wilson cell link thing. And all they're trying to do is, oh, here's an expensive expert who you think is going to help you. But in reality, they earn most of their money from the wireless industry. So they're going to shade everything to continue the wireless agenda going forward. Listen, you're in a different business. You're in the business of saying, we need to chart the course of our town. We already have enough wireless. How do we get out of the box of being forced into stuff we don't want? Well, this is how you do it. You just make sure it's all based on data because that's what the law requires, substantial written evidence. There is no better substantial written evidence than accurate DBM readings for every frequency coming into your streets. Boom, done, finished. It's not even political. Nobody can argue with it. It's here. It will deliver so much extra time to all of you people. You will have no more of these conversations. You'll have many fewer applications. The whole problem with this subject is it's so complicated. So you realize that these three blind men touching different parts of the elephant get different parts of the story. Okay, so who knows the whole elephant? Very few people. Certainly the attorneys for Verizon know it, and they do everything they can to hide parts of the elephant from you. Andrew Campanelli knows it too. He knows the whole elephant. All right, so now it's time to get the solution. Are you going to do it in a Cessna? Well, let me describe a Cessna. A Cessna is a general smart person who hasn't studied this for 10 years or more, who hasn't read all the case law, and is trying the best to knit something together. Or Andrew Campanelli, he's your solution. He's your F-18 Hornet, okay? The whole thing is you have to go behind the curtain, okay? You have to see that the Oz thing isn't as they say it is. And as soon as you go back to the laws themselves and who understands this better than Andrew, nobody. So would I say your best move is to put every idea of mine in your code? No, not necessarily. Would I say your best move is to get Andrew to put it there for $8,500, the price of a Cessna for an F-18 Hornet? Hands down, yes. That's what I would do if I were you.
All right.
Okay, so that's my conclusion. Thank you very much for your time.
Thank you, Paul.
If you have a
Thank you,
minute.
Paul.
Okay, take care.
Thank you so
Wait,
much.
Paul, hold on one sec. You still have a minute, Paul?
Sure.
All right, yeah, go ahead, Paul. Other Paul.
Can you describe the relationship between DBM and call volume?
So the bottom line is think about, yes, I can. Okay. They've solved call volume problems. They solved it technologically. It is a false argument. Okay. It's a canard. All right. It's one other part of the elephant they're trying to hide from you. Here's the bottom line. DBM is just saying, is there enough signal strength for me to talk to said tower? That's all it says. So now it's time to make a phone call. What's going on? The tower contributes some of the power. My phone contributes some of the power. We build a little bridge between us. It's a little road. We then exchange some information. And if I'm done, then the road kind of disintegrates and goes away. Okay. For making text messages, that road is a little goat path. It's not a big event. It doesn't take much energy. It's very efficient. If the whole world texted it, did nothing else, we'd be much better off. We could probably get it at minus 130 dBm if texts were the only thing. Calls take a little more energy. Okay. And so then you have to build another road. This is what they figured out. We can build roads and share them among thousands of people. There is no capacity problem on these things any longer. This is all BS. And the point is they're trying to say, oh, it's all these people streaming Netflix and everything else that's bumping our ability for the phone call. I'm sorry, you don't have to do all that. You can say, screw that. We can put enough with the DBM we have to handle all the phone calls there ever was. Nobody has to make room for your streaming video. So rejigger your own operations, but you have no significant gap in coverage because there's a good enough way for that phone to connect to the tower. There is no capacity problem unless you bring dropped call data that proves that people can't make calls. You have no evidence to assert it.
Well,
The charts that the last applicant provided showing what appeared to be dropped calls.
Did they? What did it look like? Did it say here, this call dropped at this date at this time?
It looked like there was a line of what would be something, and then there were graphs that went above it and graphs that went below it.
No. What you need is on this date, this call did not go through. That's a dropped call record. This phone number, they can fuzz out the last 4 digits. They don't have to get identifying information. This is available to them instantly. They don't want to bring it forward because they know it would just destroy their case, but you can require it in your code. Andrew Campanelli requires it in his code. It's the smartest ask there is. Give me the drop call records to prove that you have a capacity problem. And look, if they really do, well, then you talk about it. But they have to bring data to prove it. They can't just assert it and wave their hands and show you a graph. That's the bottom line. Is that's what you're starting to say. I know federal judges. I know what evidence is. What these people do to you is they just bamboozle you with this chart, this other chart, and they just lie their asses off. And this is a way to get out of the box, is just sit there and require actual real data. And don't sit there and go, oh, we'll dream up the data next year. No, Andrew has figured it all out. And just say, we will go with Andrew's recommendation for drop calls because that's smart.
Can I just ask one more, Paul? So real 5G frequencies such as like 24 gigahertz, they don't, how far do they transmit? So they really can't put an antenna on a 200-foot tower for things like that, right?
Again, this is all propaganda. The answer is, I can point out, show you that in Virginia, the NYU professor Rappaport actually broadcast his 5G signal at 73,000 megahertz, a good 6.2 miles.
Oh, okay. I thought they only
This is just all propaganda. This is all a reason for them to take cheap real estate from you and your public rights away, for you to give up your own sovereignty of your own municipal stuff. You don't want to do it. And here's why. They cannot get insurance for claims of injury, illness, or death from microwave radiation. They can't get it. And you, by allowing them on your poles, these are the street poles I'm talking about because they're under your control, you are now a joint venture partner. You are having that liability transferred to you without insurance. This is a disaster. You should never, ever let them on these metal light poles for that very reason. And if maybe they can weasel their way onto these wooden utility poles, but this is only in states where you have a bad state bill. New York and California do not have those bad state bills because smart people who work with me and people like me have defeated them and give all the power back to the locals. So now it's a city by city decision, as it should be. Look, if there is a city that wants to be the great smart city with all the 5G and that represents the will of the people, then great. That's a local decision. Go for it. If the will of the people is they don't want that and they'd rather have the least amount of it and have all their broadband by fiber, well, then please represent their interests. You don't have to knuckle under to all the, oh, we'll sue you if XYZ bullshit. Okay? It's not really there. Towns do not get sued because of their wireless ordinances. The only thing that happens is an application comes forward and they're waiting for you to make a mistake. If you just follow exactly how to say no, Andrew knows how to say no, then you don't get into court because they know they would lose. You only go to court when you make mistakes. That's the best part. Local control is where it should be. You guys should decide your own fate. That's the key.
Yeah, well, thanks for doing this because, we often have long meetings and we're limited to 3 minutes of comment from the public. So this helps a lot.
All right, no problem. And I'm just like Andrew. If you need me, I'm one phone call away. I'll help you out anytime I can. I'm going to follow up with some links directly back to Lisa if I get her email address.